First and foremost, hello everybody and welcome. Thank you for joining us today. We hope that the next 30 minutes will provide you with some insight around everything you need to know around the Employee's Guide to What, How and When, our delightful webinar topic for today. For those of you that's not joined one of our webinars before, we are here at the Curve Group. We are extremely proud of what we do. The Curve Group is a leading provider of configurable HR and recruitment services, and we support businesses with their entire employee life cycle on an outsource, a project or a consultancy basis. We operate as a replacement or a complementary solution to your existing HR or recruitment team. Our clients benefit from engaging on a single provider to deliver their operational and their strategic needs. And as I've already said, we are extremely passionate around what we do and the way that we transform working lives. The webinar is scheduled for about half an hour today, and that includes time that's built in for questions and answers. In addition to that, if you do have any questions as we go along, please do feel free to use the Q&A facility on your toolbar. As I've already said, here at the Curve Group, we are incredibly proud of what we deliver. Here in front of you on the slide now is just a range of some of the selection of awards that we have achieved over the years. For those of you that are lucky enough to ever have come to Curve HQ, you will absolutely see these dotted about the building. And as I say, we're incredibly proud of them. So joining me today is Keith Allen, our PMO Director, and I'll shortly be handing over to Keith. My name's Anna Clapton and I'm the Head of HR Consultancy. And again, as you'll see on the screen now, you've got our email addresses. What we will do post this session today is send you all a link so that you have the recording of the webinar. And of course, you can look at our main insights page on our website and see all of the recordings of our previous webinars that we've run as well. So what have we got coming up today? We've got an introduction to the right to work in the UK, why prevent illegal working, typical routes for obtaining statutory excuses, benefits of incorporating digital right to work route into your organisation, obtaining that statutory excuse, headline process, because as you can imagine, something like this goes into a lot of detail, common mistakes that organisations make, and some key takeaways for you. What I'm going to do now is hand over to Keith, who's going to take us through the body of the session. So Keith, over to you.
Thank you very much, Anna. So first of all, we're going to jump into the statutory excuses. So as you most probably know, all employers in the UK have a responsibility to prevent illegal working and obtain statutory excuses for each of their workers that they employ. It's quite simple to do this. You conduct simple right to work checks before the individual commences employment to make sure that, number one, the individual is entitled to work in the UK, and number two, that any restrictions to employment is considered in line with the requirements. So how long are they allowed to work in the UK for? How many hours are they allowed to work for? And are there any restrictions to the type of role or some type of function that they're allowed to work in your business? By conducting the right to work checks as per the guidelines, you will gain a statutory excuse for that worker, which can then in turn negates any potential consequences, which we're going to come on to shortly. If an existing employee has any right to work restrictions, then also you need to make sure that you conduct these during the term of their employment. Maybe it could be that there is time limited, if they can only work in the UK for 2 years, you need to do it before the 2-year period is up to make sure that you retain that statutory excuse. At the bottom of the page there, you'll see a link to the actual legislation, which goes through all of the detail involved in the statutory excuses. So why prevent illegal working? So you mitigate illegal migration and exploitation of vulnerable people, reduce labour market abuse, reduce modern slavery in the most serious of cases, mitigate reputational damage, because all civil penalties issued are publicly available. And the last thing you want to see is your company name splattered onto the press, onto social media to say that you're employing people illegally. You prevent disruption to operations in the event illegal workers are found and removed. Because if you do have an illegal worker found, then they will be removed, which means that other people would then need to pick up the aspects of that job role. And then finally, you avoid serious penalties and sanctions, which we'll come on to now. So the penalties and sanctions, it could be a civil penalty of up to £20,000 per illegal worker. As of January 2024, this is going to be increasing to up to £60,000 per illegal worker found. In serious cases, it could be a criminal conviction, carrying a prison sentence and an unlimited fine. the business could be closed down. Company directors could be disqualified from operating with a directorship, and also that could impact them in the future from holding directorships as well. Not being able to sponsor migrants, which means your talent workforce is then restricted. We've got a lot of great talent globally, which you may be tapping into, and you may lose the ability to be able to do that. And then there's the seizure of earnings made as a result of illegal working. So let's say, for example, you had a salesperson within your business that brought in £2 million worth of revenue over the last 6 months. If they are found to be an illegal worker, not only might you face any one of these other penalties and sanctions, actually the revenue they brought in during the term of their employment could be seized by the government. So as you will see, all of the penalties and sanctions are quite significant. So how do you move away from this then, or around this? So there's 4 different routes to gain in the statutory excuses. The 3 we've got the most predominant ones, which is the digital. Digital route was launched in October 2022 and has by far becoming the fastest way of companies adopting to gain the statutory excuses for people's right to work in the UK. You've then got the share code route, the typical manual route, which was historically the route that most people followed. And then you have got a backup option, which is the employer check-in service as well. Now, you will note as well that most of these routes cannot be facilitated apart from by the employing company, with the exception of the digital route, which you can as such outsource to a screening provider to facilitate the doing, and then you do have some obligations on the back of that as well. But we will come on to that in this next slide. So we've got the benefits of incorporating the digital right to work. So like I say, this is the fastest growing way that companies are making sure that people do have the right to work in the UK. So this actually reduces the manual route being used. So it's less labour intensive. So it means you haven't got to coordinate and certify documents. The candidates and the hiring managers receive a better experience because they haven't got to worry about what documents they need to take, go through the pain and the ordeal of making sure they get copied, witnessed, certified, and then stored. There's a reduced risk of documents not meeting legislative guidelines. So what this means is if the wrong documents are taken or someone's forgotten to take the documents in. For example, one of the most common ones that I'm experiencing from our customer base is where driving license are being taken as a proof of right to work. We will come on to that a bit later on, but it won't meet the statutory requirements for gaining the statutory excuse. Reduced GDPR risk owing to the reduction in volumes of documents being copied, sent on email, remembering to delete them, or even hard copies as well, making sure that they get destroyed. So there's a huge GDPR benefit there. And also then, where criminal checks are required, the digital ID route actually can serve the purpose of not only the right to work, but also criminal check. So it kills 2 birds with 1 stone. You'll see from the graph, it's just a bit of an illustration. The red bar is the manual route that historically most companies would be operating to, but you'll see now the green bar has massively overtaken this. So this is the digital route. So the manual effort on the right-hand side, you'll see, is being reduced significantly to not have to worry about all of these different factors I've just been through. So putting it a bit more into context then. So at the very top of the page, you've got a link there, which is the Legal Right to Work UK. It's a government link. This is a simple tap-through screen, government platform that you can determine which is the route that you need to take for your individuals. So you've got the digital route. Let's take the first one. This is only available to British and Irish nationals that hold a valid passport. This is really important. So a valid passport is a passport that's in date and contains all of the correct details for that individual. So for example, if someone has been married or changes their name by deed and that passport doesn't contain their new details, that is not considered as to be a valid passport. It has to be accurate of all the information contained. So once you've been through the digital route, so the individual has typed all in all their information, they've done the selfies through the different platforms, then the digital report then you will then get, and you need to do a true likeness to basically determine that individual went through that digital route is an accurate representation of the individual that you've employed. And then you need to hold this on file. Other than a digital report, you don't need to hold additional copies of the passports or other documents. That's a very common misconception there. I do recommend that a record of the date and who conducted the true likeness of that report is held on file. This is not a legislative requirement as it stands. I do believe it will come into force at some point, but this is your check and validate. Just make sure you save it down, because if the government does change the rulings, at least you protected yourself. And it does say there how long you also need to retain a copy of that report and the certification as well. The share code, so you've got a share code link there to actually use so that you can view people's share codes. When you view someone's share code, you just need the actual share code number and the date of birth of the individual. Now, typically, not in all circumstances though, but people that require visas and work permits will have a share code. By law, this is really important, right to work expiry dates on the share code report are the dates that you need to go by. So if you're looking at the biometric residency cards, then you cannot entertain that as being a truthful, legitimate source of information. You have to go through a share code. Other than the, so you need to do a true likeness check of that share code report again, just to make sure actually that is the same person on that report of what you're due to employ and held on file. And again, share code reports, you don't need to retain copies of passport, visas, other documents. The share code report is suffice. Again, I do strongly recommend you record a date and who conducted the true likeness check and hold that on file as well. Again, it says how long you need to retain that information for. The manual route, there's another link here as well. So I do recommend, strongly recommend, that whenever you're taking documents manually and witnessing them, certifying them, you refer to the checklist, because sometimes people are a bit unsure as to what documents are permissible or not. So where documents are permitted to be accepted, they need to be witnessed, copied, certified, and held on file, which is standard for most employing companies that have done this in years gone by. I do strongly recommend that a further check against legislation is applied prior to saving the documents down as well. Again, there's been so many instances that I'm aware of where, for example, a share code report, but the wrong element of the share code report has been saved down, or a driving license has somehow been crept into the statutory excuse for the right to work. As I've said before, the driving license will not give you the statutory excuse. And then finally, you've got the employer check-in service with a link at the bottom there as well. So if you're really unsure of where to go to for this, or which route to go down, then make sure you are hooking up with the employer check-in service as well. They will be able to help you. So putting it into a process. So what I've put here is a practice and a process of elimination, where all individuals pass through the digital route, regardless of nationality. This approach then delivers consistency and robustness within your organisation and gives you a tick box for compliance purposes as well. So we're presuming that we would take receipt of a digital right to work report. Now, the outcome of that might be that the right to work has been validated. Well, in which case you would undertake the true likeness check, and then you save the digital ID report and the true likeness confirmation. Easy stuff. If the right to work isn't validated through the digital route though, you would then maybe need to undertake a share code route check. So you would undertake the share code check, do the true likeness, and again, save that share code report and the true likeness confirmation. There may be restrictions to, how long the individual can work in the UK for, how many hours they're allowed to work, or what job functions they're allowed to undertake. You then check periodically on those restrictions. So that might be a quarterly thing or an annual thing that you're undertaking. And then you need to make sure you're taking preemptive action. So if you know that someone can only work in the UK for maybe 5 years, you need to make sure that you're putting enough measures in place in good time to make sure that that statutory excuse is retained. Maybe the individual isn't entitled to have a share code, in which case you may be permitted to follow the manual route. Again, at the top of the page on one of the previous slides, I did show you the click-through platform, the government click-through platform, which will really help you determine what you're allowed to do and not allowed to do. So if you're entitled to follow the manual route, of course, you would witness, copy and certify the documents. You would check the witness documents against the legislation and the certification as well. You do want to make sure that they've been certified correctly. And then you'd save the documents down. And then you'd follow the same procedure as the share code, record any restrictions, check in periodically any restrictions, and then take preemptive action where required. Again, if the government click-through platform suggests that you can't do any of those or you're really stuck, then please do seek guidance from the employer check-in service. Now, it might be at the very bottom of the page that you determine that someone hasn't got they're not a British or Irish national, or they don't have a valid passport, in which case you may default then to one of the other procedures. Hopefully that gives you a bit more of a visual as to how to process the different right to works. So common mistakes, British and Irish nationals in particular, because by far they are the biggest workforce that are employed across the UK. So key tips for manual routes of demonstrating right to work in the UK for British and Irish nationals specifically. So out-of-date passports. So this is following the manual routes. So out-of-date passports are acceptable documents for demonstrating right to work. So that is only for British and Irish nationals only when you're following the manual route. They have to be an in-date passport if you go down the digital route. If the person's name has changed, of course, you need to back that up. So maybe a marriage or deed poll certificate to back up actually the difference between the detail in the passport versus what the actual individual is called at that point. Driving licenses cannot be used for right to work purposes. Proof of addresses are not required for right to work purposes. It's onboarding. A lot of companies do actually request the passport, proof of address, etc. You do not need them for proof of address for proving the right to work. It may be suffice for payroll, for example, though. Birth certificates is not alluded to very well in the government platforms, but birth certificates must be the long version. So a lot of people are taking the short version. That will not give you the statutory excuse. Where photo ID doesn't form part of the right to work documentation, so let's say that a passport, for example, isn't used, then what I do strongly suggest is you do ask the individual if they've got maybe a driving license, not that will give you the statutory excuse, but it just gives you the confidence that that person that is being employed, when they're presenting maybe their national insurance number and their birth certificate, you can marry up that individual to those documents being presented. So I do hope that clarifies some of the most common mistakes that some of our clients are facing. So key takeaways, there's quite a lot of detail on here, and there is another page as well, but as Anna said, you will get a copy of this after the webinar as well. So first of all, employing companies should be obtaining statutory excuses before day one of the employee's first day. Now, this is really important. The minute that someone commences their employment on day one, if you are investigated and you do get immigration come in and you're found to be employing a illegal worker, even if it's 1 minute, for example, past 9 o'clock in the morning, then penalties and sanctions may apply. So always do it prior to first day. The digital right to work route mitigates time and risk, as we've been through before. So if you haven't got that in place already, then I do recommend that you investigate that and move that forward. During the recruitment process, ask probing, but make sure they're not discriminatory screening questions. And that will really help you determine what nationality are they? What are they going to be able to provide, which is going to provide that statutory excuse to you as the employer? Where the manual route is followed, it needs to be really clear within the organisation who's going to tell the candidates what documents do they need to bring, maybe to the interview, for example. Who's going to be certifying them? How are they then going to be certified? How are they then going to be held in the HR system? So considering all of these different things around responsibilities is really important. The same as the share code as well, making sure it's clear as to who gets the share code and the date of birth from the candidate. Who's then processing that on the government platform? Who is then doing the true likeness, and who then is saving it down? And the same for the digital right to work as well. So making it really clear the roles and responsibilities of who does what and when. It's recommended that a further sense check, for example, by HR, should take place to make sure that when you get a copy of the share code report certified, or the digital right to work report, or the manual documents that are being certified and provided, that actually they are going to be suffice, that they're not blurry, they are the right documents, they have been certified correctly. Make someone to do a sense check just to make sure everything is in order prior to saving them onto the HR system. Don't forget GDPR. of how are documents going to be taken, when do they get taken, what documents have been taken, how are you going to transfer them from A to B, where are they getting held. So it's really important at all times thinking about this really sensitive information to make sure that they don't fall into someone else's hands that doesn't have the entitlement to be witnessing and having access to them. And I did say, I missed one point, which is around where any right to work restrictions apply. The employing company should ensure that measures are in place to keep monitoring them as well. So like I said, you need to put in those periodic checks, right? Who's got what restrictions for their right to work in the UK, and making sure that before the relevant time period, you're taking preemptive action to make sure you retain that statutory excuse. And then finally, the contract of employment should always be robust enough to rescind employment. So for onboarding of a new starter, it's really important you've got it in your contract of employment that if they don't have and then maintain and retain the right to work in the UK, that you have the option to terminate their employment. Because then what that also does is during the term of their employment, let's say they're on a visa and their right to work in the UK then lapses, then what allows you to do is if they can't get the new right to work in the UK, then you have the option to terminate their employment. And then finally, on the last page, so to demonstrate corporate social responsibility and reputational damage, contractors as well. There's a very grey area around the government legislation around what is classed as an employee. An employee is someone that is physically payrolled or works for you. So what I do strongly recommend is that contractors, whilst they might not be employed, they will be providing services under the banner of your organisation. Make sure that you have got enough due diligence to make sure that the limited company or umbrella company is also conducting the right to work checks as well for the individuals working for that contracting company. Reports and documents must be held either in hard copies or scanned copies, but you have to make sure they're in a format that can't be manually altered. So, for example, JPEG or PDF. When manually certifying documents, there's just a bit of a tip here. You just need to make sure a note of the date that the check was conducted and also who did it as well. So I have noticed previously for many years in the past where people write War and Peace, big essay around the certification side of things. Keep it nice and simple, the date that the right to work check was conducted and then who completed it. If some clients, what they're doing is taking a copy of, let's say, a passport when they're doing the manual right to work, they're taking copies via a phone and then emailing that straight on to, for example, HR. You don't have to certify the actual document, the attachment itself. As long as you're putting in the body of the email when you're transmitting that email with the attachment, you can just put in there the same thing, date of the right to work check and conducted by. And my very last snippet of information at the bottom is around liability, accountability, and responsibility. So it's the employing company that's going to be liable for maintaining the statutory excuses. And if you don't retain the statutory excuses, it will be the company, the employing company, that's liable for those sanctions and penalties. Accountability, make sure that there's always someone accountable within the organisation for making sure that statutory excuses are gained before day one and also retained thereafter. And then responsibility. So it might be that it could be the HR manager, for example, that is accountable, but they share that responsibility with maybe hiring managers or HR administrators for making sure the business conducted all of these activities and follow up to make sure everything's complete. So keeping you nice and safe and retaining those statutory excuses. So there's lots of information. I could talk on this subject for many hours, but hopefully that gives you a bit of a snippet into the best practice to be adopting for employing companies and making sure you're safe and sound when employing people for the right to work in the UK.
As Keith said, this is a subject that is very passionate to his heart and he can talk about it for hours. So if you do need a helping hand in any pre-employment screening services, both as part of a HR and recruitment outsource solution, we would be more than happy to hear from you and more than happy to support you. As always, we will be running future webinars, but we are now going to take a break up until the new year. And then what we'll do in January, we will be announcing the date very shortly, is we will run a webinar on the vision for 2024 and what is next for HR and people leaders. So we're very excited to be working on that topic already. As I've already said, you will get a recording of today's today's webinar. And in addition to that, if you want to see any of our past webinars, then please do go onto our website and into our Insights tab. And finally, all that's left for me to say is, on behalf of Keith and I, thank you very much. It's been a pleasure having you with us this morning and today. And we look forward to hearing from you in the future if we can support you in any way. Thank you very much.